Okay, so this morning's section is going to focus on an introduction to the UN Convention on the Rights of Persons with Disabilities. Okay, everybody down? Great. Okay, so today we have two really interesting speakers that will present two different perspectives. So first, we have Professor Rosemary K.S., who's Senior Research Fellow and Senior Policy at the Social Policy Research Centre in the University of New South Wales. And so Professor Rosemary K.S. focuses on the equality provisions within international instruments and their translation into domestic law and policy. She's also Senior Research Fellow within the Social Policy Research Centre, and her research very much focuses on the experience of working and advising on a variety of social research projects, including access to justice, social inclusion, human rights, disability, and the implementation of CRPD in Australia, Asia, Pacific, and Europe. So Rosemary will speak for about 40 minutes, and then our second speaker, Dr. Kira Smith, will focus on CRPD reservations and declarations. And Kira is within the School of Law here within NUI Galway, and her research very much focuses on the area of international European and Irish refugee law, and is particularly interested in how refugee law and rights law interact. And Kira's recent work looks at the common European asylum process and looks at currently undertaking a comparative analysis of international and regional norms concerning the immigration detention of children. So what we're going to do first is have Rosemary speak for 40 minutes, and then we're going to move straight through to Kira, and at the end we're going to have questions and answers. So please engage with the sessions, and please retain your questions for that period of time. Okay, we do have about 20 minutes to make up, so we are going to progress this reasonably quickly and efficiently and as effectively as we can. Okay, so if I can ask Professor K.S. to start, and I'll establish your presentation.
My mic's off. Yeah. Okay. First of all, I would really like to thank everybody for their incredibly generous words on my election to the committee. I think you're all being a little bit, way too generous with what you think I might be able to do on the committee. And the other thing I would really like to note is the global leadership that Teresia Degner has given in this area. Her last 2 years as chair on the committee, as being the only woman on the committee, was absolutely brilliant. But the legacy she leaves through her academic and legal rigour in the work of the committee will be one that will be very hard to follow, but we'll give it a crack. I've just heard we've got to make up, oh God. Jeez. It's bad enough I've got to wear this silly thing. I've just been told we've got to make up 20 minutes. I'm always in this position, and I'm always the last person that can make up time for anybody. But anyway, we'll give that a crack as well. What I'm going to be talking about this morning is the obligations contained within the CRPD. I was speaking at an event in New York last week, and I described the Convention on the Rights of Persons with Disability as a truly 21st century human rights instrument. First and foremost, because it recognised that people with disability are just one aspect of the human condition, that disability was just an element of human diversity, and that we all experience disability and discrimination in a multiplicity of ways. And CRPD is one of those is a truly 21st century instrument, because it, as opposed to the other thematic instruments, takes us on the beginning of the journey to recognise the multiplicity of ways in which people experience their personal identities. We'll be talking about this right throughout the week, but I want to start now with looking at what the obligations are that are contained within the instrument and how they can relate back to intersectionality. Just briefly, Teresia has highlighted this in her keynote address earlier, but just briefly I want to touch base again with the antecedents to CRPD. Disability for a long time had been seen as an individual deficit, and that the response to that individual deficit was seen in terms of care, treatment and protection, and that people with disability were defined by notions of care, treatment and protection. We were seen as problems to be cured, and hence contained within notions of being objects of welfare and care. This translated into a policy program of special laws and programs, so special education, sheltered workshops, residential care and guardianship, that led to a history of social exclusion and economic and social disadvantage. What CPRD has done has taken us out of that approach and embedded disability within a contemporary approach. So as I said, disability is just one aspect of human diversity, and a recognition of the concepts embedded in terms like impairment and disability. So the recognition of the dynamic relationship of people with impairments and the social environment. And in understanding that dynamic relationship, you identify barriers to inclusion. And this is the fundamental premise of the human rights approach. A human rights approach establishes people with disability as rights bearers, and that there is a moral, and in terms of the treaty, a legal obligation to remove barriers. So what is CRPD? At its most fundamental, CRPD is a human rights treaty adopted by the United Nations General Assembly in 2006. Its purpose is to promote and protect the rights of persons with disability and ensure that these rights are fulfilled. It also aims to promote respect for inherent dignity of persons with disabilities, and it has an associated optional protocol, which is a separate treaty that allows for individual communications to the CRPD treaty body about CRPD right violations, and allows the CRPD treaty body to conduct inquiries into grave or systemic violations of CRPD rights. Now, the CRPD as an instrument is a comprehensive or a hybrid human rights treaty incorporating social development, non-discrimination, and other human rights subject matter, meaning that it is an instrument that combines the different levels or different generations of human rights. So it incorporates civil and political rights. It incorporates economic, social and cultural rights, and arguably some new classes or types of rights That's not saying that it develops any new rights, but there is expression of rights as new classes of rights. Now, Teresia hinted to this earlier with discussion about accessibility. Accessibility is a collective right or what is considered a third generation right. So a new class of rights. It's a thematic convention in that it deals with the human rights concerns of a specific population group. So the status of the CRPD is the same as other core human rights treaties. So it's the same as the International Bill of Human Rights, which are the instruments of general application, and that the International Bill of Human Rights is made up of the three general application instruments: the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social and Cultural Rights. It also holds the same status as the other thematic human rights treaties, such as the Convention on the Elimination of All Forms of Discrimination Against Women and the Convention on the Rights of the Child. So what this means is that for the first time, human rights of persons with disabilities are of central importance to the international efforts to promote, protect and fulfil human rights. The rationale behind the CRPD was because of international concern that the existing human rights instruments had failed to effectively protect the human rights of persons with disabilities. And even though they've always applied to persons with disabilities on an equal basis with other persons, so other status was the way in which disability had been recognised through the instruments of general application previously. So under ICCPR or under ICESCA, persons with disabilities could make claim against the instruments of general application. What was problematic was that there was no normative content to frame what those obligations should entail on states, and little expertise to be able to clarify that in the development of jurisprudence. See, I'm not very articulate. So CRPD attempts to overcome this problem by ensuring that persons with disability are highly visible rights bearers. So it has a symbolic application. It then tailors and applies traditional human rights to some of the specific human rights problems of persons with disabilities. And most importantly, I believe, it's about building capacity in human rights implementation efforts to effectively respond to the human rights of persons with disabilities. So that's about identifying the fact that there was little or no expertise or understanding of disability from a contemporary position to inform policy, to inform jurisprudence, and to inform implementation. So the building of capacity within human rights implementation is central, I believe, to addressing the violations of persons with disabilities' human rights. So, its relationship to other instruments. All other instruments continue to apply to persons with disability on an equal basis with other persons. So, CDAW, for the Convention on the Elimination of All Forms of Discrimination Against Women continues to apply to women and girls with disability on an equal basis with other women and girls. Therefore, CRPD must be implemented in an integrated way with other human rights obligations. So it gives rise to two related implementation concepts, the Twintrack approach and the mainstreaming approach. Now, this has started to be highlighted in this morning's discussion when we talked about the fact that there was, or there is, a specific standalone article on women and children. So Article 6 and Article 7 are within CRPD. So there's standalone recognition of the multiple discrimination that those particular population groups can experience. Then there is the mainstreaming or the embedding of both a gender perspective and an age perspective throughout the obligations, throughout the specific obligations in the text. And so the issue is mainstreamed throughout the text at certain points, clarifying to states what their obligations are to those two intersectional areas. In terms of how that relates to the other instruments, and I too was also in New York last week when Anna Pelez was, the week before when she was voted on to the CDL committee and was incredibly ecstatic by that. It is with the cross-population of expertise that we will truly be able to mainstream and to address intersectionality and give greater coherence and uniformity across international human rights law. And so Anna will bring expertise to the CDL committee and be able to mainstream disability into their jurisprudence. Generally speaking, the CRPD supersedes earlier non-binding disability-focused human rights instruments. So any earlier jurisprudence from any of the other instruments related to disability, CRPD should supersede. The principle in international law is lex specialis versus lex generalis. So in other words, the special law supersedes the general law. So, the interrelationship between rights and obligations. The key interrelationships between categories of CRPD rights, dynamic rather than linear in structure. So the rights aren't hierarchical, but they are dynamic. So they all interrelate. You cannot look at rights in isolation to other obligations. There is cross-cutting, So to ascertain the scope of each specific obligation, it's necessary. I'm really conscious I'm giving you my back, I do apologise. It's necessary to consider its intersection with each of the interpretive articles, general obligations, and national implementation and monitoring articles. So an article is never seen just in isolation. There are other facilitating and implementation measures that need to influence the interpretation and understanding of the state obligation. Also, there are important interrelationships between some specific obligations, implementation action in relation to closely interrelated rights or to be coordinated. So there will be rights that have, I suppose you could call it, a strong relationship with each other. And you will need to understand the obligation in both rights to be able to tease out what the obligation is under another right. So, if we look at women in Article 6, we've developed up an answer here. So, the intersection of Article 6 and Article 10. So, Article 6, women with disabilities, states parties recognise that women and girls with disability are subject to multiple discrimination, and in this regard shall take measures to ensure the full and equal enjoyment by them of all human rights and fundamental freedoms. So to understand that particular article, you then have to go to a substantive article to look at how that might be implemented and what obligations states might hold. So, Article 10 on the right to life, states parties affirm that every human being has the inherent right to life and shall take all necessary measures to ensure its effective enjoyment by persons with disability on an equal basis with others. So what is the interrelationship of those two articles? Well, in terms of measures, what it might turn out to be is breast screening equipment is accessible for women with disability who use mobility devices. Women with physical disabilities have a greater prevalence of breast cancer than the general population. And it's been indicated that it's because mammograms don't successfully capture full screens because of the nature of the machinery. I suppose you call it machinery, the machinery of the actual mammogram itself. So lots of lumps get missed in those tests. So their right to life is at risk because of the nature of mammography equipment. Women with intellectual disability are supported to participate in regular cervical screening on the same basis as other women. The health status of women with intellectual disability is generally far lower than the general population because their access to primary health care is reduced. So, with support, women with intellectual disability should be able to be availed public health screenings such as cervical cancer screening. So it's about access to information and about access to support. And also that emergency accommodation services for women escaping domestic violence are accessible to all women with disability. So women with disability should have access to the same safety mechanisms that can get them out of dangerous risk situations with domestic violence. And that means that any refuge should be accessible, that information about leaving dangerous domestic violence situations should be accessible, and that disability organisations are also funded and supported to be able to assist women with disability who are in domestic violence situations, for them to be able to remove themselves from that risk so that their right to life is protected. So, as I mentioned earlier, the overarching context of CRPD is captured throughout the instrument, in the sense that the underlying policy is developed in the preamble, Article 1, the purpose, and Article 3, the general principles. So it sets out the antecedents to the CRPD, both the legal and the overarching policy, underlying policy, sorry. Its positioning is one of persons with disability as human rights bearers, and disability concerns as human rights challenges. And as Teresia identified, during the negotiations, the overarching frame of reference was the social model. We now have greater understanding of how the social model, in combination with now a human rights framework, can change that. But when the convention was being negotiated and drafted, the overarching theme was the social model. And so it came back to that interaction of a person with an impairment with the environment, and that the action implication was to dismantle barriers to the full enjoyment of human rights. And you will see that states' obligations almost exclusively are focused on the removal of barriers. So, there's several layers of obligations on states and different types of articles. Not every article is a substantive right. There are general obligations. So there are general obligations that tease out about the areas of research and the importance of civil society engagement. There are also facilitation articles, articles that facilitate the fulfilment of other articles. So the general principles, women and children, awareness raising, accessibility, data and statistics. Now, accessibility is a bit of a hybrid article. It is both a facilitation measure as well as a substantive right. The others are not substantive rights. They don't confer any individual rights, but they facilitate the implementation of other substantive rights. There are translated rights. There are rights that don't just reaffirm rights that are established in other instruments, but have been translated from either earlier international law jurisprudence or a reframing of traditional human rights. So freedom from violence and abuse has picked up elements of CRC, the Convention on the Rights of the Child. Protecting the integrity of the person has been picked up from jurisprudence of the Convention Against Torture, ICCPR, and the European Charter of Human Rights. Living independently and being included in the community is a transformation or a translation of the right to the freedom of movement. As is personal mobility. So they take traditional rights and frame it in terms of a very specific application in a disability context. And then there are implementation measures. Again, they are measures, they do not afford individual rights. So situations of risk, rehabilitation and habilitation, access to justice, and international cooperation. These are obligations on states that they need to implement to be able to ensure the fulfilment of other substantive articles. The general principles are the core foundational values to guide and underpin CRPD interpretation and implementation. So respect for inherent dignity, the right to autonomy and independence, respect for difference and acceptance of impairment and disability as part of human diversity, the right to inclusion and participation in society, right to equality and non-discrimination, the right to an accessible environment, the right of women and girls to equality, and the right of children and young persons to recognition of their specific needs. So these 8 principles inform the interpretation of each substantive article. So a state, in terms of understanding its obligations, needs to consider these underlying values when respecting, protecting, and fulfilling each substantive right. Next. Yeah, sorry. So, cross-cutting obligations. Cross-cutting obligations must be taken into account in the interpretation and implementation of each specific obligation. So, general obligations that set out the overarching general obligations that states hold. Equality and non-discrimination, Article 5. Women with disabilities, children with disabilities, awareness raising, accessibility, stats and data collection and national implementation and monitoring. So the general obligations are about repealing discriminatory legislation, repealing, revoking. If I was a real academic, I'd have all the words here, but I don't. Equality and non-discrimination, so being able to protect people from acts of discrimination by the state and or third parties. As we talked about, women with disability and children with disability need to be considered in terms of the multiple discrimination that they can experience. Awareness raising, so what form of awareness raising of rights or particular specific rights is being undertaken. Accessibility, so through technological and the provision of technology and science developments, but also in terms of the environment. Statistics and data collection to ensure that disaggregated data is informing policy development. And national implementation and monitoring, ensuring that both the general obligations but also that there is a monitoring mechanism that captures the whole of the state's obligations under CRPD. So, there are core levels of human rights obligations. So, recognition of the treaty must enact laws and develop policies and programs to give effect to CRPD rights. So it must in some way be implemented within the domestic framework. There are a few states that have immediate, God, I really have lost it. I'm a little bit jet lagged today, I do apologise. I generally don't experience very often. It's not very nice. There are a few states that upon signature, the international instrument becomes part of their domestic law. They are very few and far between. I think there's about 3 of them. The rest have to translate international law into their domestic regime. Most states are guided by parliamentary sovereignty, meaning that any legislation has to come through their parliament. So lots of CRPD rights have to be translated through national parliaments before they can become part of domestic law. So respect for treaty rights, states parties must refrain from action that arbitrarily interferes with CRPD rights. So they shouldn't act in a way that violates CRPD rights. So protect treaty rights, states parties must prevent non-state actors from arbitrarily interfering with CRPD rights. So what mechanisms are you providing people with disability to seek redress or protection if rights are being violated? Are there laws in place that stop third-party actors from engaging in a discriminatory manner? And then fulfil treaty rights, states parties must take positive action to ensure that treaty rights are realised in fact. So this is where states parties must take action to ensure that rights are realised. So these are the positive obligations on states to do something. Yep. All right, so this is just an example, again using the right to life. So the level of obligation, recognise, enact legislation incorporating the right to life, including its CRPD elements into Australian law. I'm Australian, I use Australia as examples. So, and also to combat negative social attitudes that view the lives of persons with disability as less valuable or worth living than others. So Australia doesn't have a constitutional provision for the right to life. So we would need to enact through Parliament legislation that establishes the right to life. Because we have a federal system, there are some states that have statutory human rights charters, and they do recognise the right to life. So the right to life is still recognised in a piecemeal manner in Australia. So the respect level on the obligation on the right to life is measures such as abolishing the death penalty. and strictly controlled state security forces. So stopping the army and the police from arbitrarily shooting people and people with, and the Victorian police have a horrible habit of doing it with people with psychosocial disability in Victoria. Protect, to enact laws prohibiting homicide. So you could have a disability dimension to that in the area of neglect. So, children with disability that have been neglected and have died through lack of nutrition or lack of access to primary health. Enact laws prohibiting discrimination against persons with disability in the provision of medical and health services. Or to fulfil, ensure that public health measures, for example in tobacco control and nutrition, equitably target persons with disability. Or establish policies and programs to meet the specific health needs of persons with disability. So as you can see, those 4 levels of obligation require different measures or different actions by states. The standards of obligation, civil and political rights, have traditionally been understood as immediate compliance upon entry into force of the treaty, whereas economic, social and cultural rights have progressive realisation over time. This is a fairly separate way of looking at the standards of obligations. I would suggest we have moved on somewhat, and there's recognition within jurisprudence, within some areas of international law that recognise that all rights, all human rights, are immediately realisable to the maximum extent possible. There are civil and political rights, which are always seen as negative rights or rights of non-interference, that do have a dimension of state action that is required, and depending on the resources of the states, may have a progressively realisable argument. But essentially, all human rights are immediately realisable to the maximum extent possible. For social, economic and cultural rights, that is not, progressive realisation is not an ability to put off undertaking measures, that there are measures that can be taken within limited resources. So it can't be indefinitely delayed or a failure to take action. All action must be continuous, and regression is not permissible. You must take action to the maximum extent permitted by available resources, and that will vary from nation to nation. And implementation measures must be equitably distributed with a focus on those most disadvantaged.
You have 1 minute.
Yep. Each article deals with a specific subject matter. Some articles have multiple elements derived from existing human rights, but specific application of these rights, affirmation of existing rights with respect to persons with disabilities, so again, right to life, affirmations of existing rights with disability-specific measures, so equal recognition before the law, and new specific applications of traditional rights, so living independently. And there are 20 articles, 15 civil and political rights, and 5 economic, social and cultural rights. I'll leave it there, since I know I'm not going to make up any time, but at least stop on the 40-minute mark. I can assure you there's not that many more slides to go, and they didn't do anything more than just round off what we'd already been talking about. But the main thrust of it is that there is intersectionality built into CRPD. There is a strong interrelationship with all rights. You cannot read rights in isolation. You need to have an understanding of the treaty as a whole. And I'll leave it to Kira to explain the fraud area of reservations and declarations. Thank you.
Thank you so much, Rosemary, for being so on time and for giving such an excellent overview of the obligations and some of the elements of intersectionality. So we're going to move straight on to Kira, who's going to speak about the reservations and declarations. And again, maybe just keep your questions till the end and we'll have a full questions and answers session at the end of that. Okay, Kira?
Thank you very much for inviting me to speak to the organisers. It's difficult to follow in the footsteps of Rosemary, who did such a wonderful view in elucidating the legal obligation inherent in the CRPD. I've been asked to speak about reservations and declarations, but I'm actually not really going to speak about that. I will address it. Because we can't really understand about reservations and declarations without placing the CRPD in its broader public international law context. So I'm going to speak trying to place the CRPD both in broader public international law terms and in its field of international human rights law, and I will address reservations and declarations as part of that. Just two things to say at the outset. One is I have a bit of a cough, so you'll have to bear with me and just get my water. If I have to drink lots of water, I do end up coughing. And the second is to say that I'm actually, as you will have gleaned from the introduction, I'm not a disability law expert by any measure or means. International human rights law is something I teach. My own specialist area is international refugee law. So I'm just stating by way of caveat at the outset that this is not my area of expertise, but I hope I'll still have something of interest to say. Okay, so I want to begin by making saying a few words on international treaties, because obviously the CRPD is itself an international treaty. Of course, international treaties are just one of the major sources of international law. The other major source, you might be aware, is customary international law, and it's of equal validity as treaty law. And customary international law, I'll come back to this later, but customary international law is when states follow a particular practice, and more states follow that practice until eventually almost all states are following the practice in the belief that it has solidified and become law. And there's also some secondary sources of international law like judicial decisions and so on. Treaty law is very much one of the primary sources of international law. States negotiate, sign and ratify a treaty, or they accede to a treaty if the state has not been involved in negotiating it. Why do states do this? Well, the impetus for states is that there's some perceived mutual benefit in signing an international treaty. Okay? So if you think about the typical areas of international law, areas like international trade, or international environmental law, or civil aviation, or the law of the sea, it becomes clear that states have to negotiate and talk to one another to resolve issues that arise. For example, in regard to the law of the sea, there's a lot of what we call international waters out there, and states are going to have to talk to each other and arrive at some kind of agreement as about who gets to go in those international waters, who gets to explore, what happens if there's a collision in the high seas, and so on. So usually when states sign a treaty, they're doing so because they perceive that they're going to benefit from reciprocal rights and obligations. So they're doing it in their own interests, essentially. Treaties are legally binding on states that have ratified them. Why are they? They are legally binding because the states have given their consent to be bound. And this is the doctrine of pacta sunt servanda. States are bound because they have signed. A little bit like when we make a contract. So states are bound by them. They are legally binding at the international level. And at the international level, treaties supersede conflicting domestic law. So if there's a clash between an international treaty that a state is party to and some provision of domestic law, then the international treaty will prevail. And this idea of the supremacy of international law has been around for a long time. It's one of the first cases that found that international law is supreme over domestic law occurred after the American Civil War. So it's been around for a couple of hundred years, and it's reiterated in Article 27 of the Vienna Convention on the Law of Treaties. And Article 27 says states can't rely on their internal law as an excuse or a justification for failure to perform a treaty obligation. So that's a really important thing to note at the outset, that when states sign up to a treaty, they are legally bound at the international level, and they cannot use the deficiencies of their domestic legislation as an excuse not to perform a treaty or a justification not to perform a treaty obligation. Now, that's the good news. But on the other hand, the bad news is that a treaty may or may not have domestic effect. And this depends on whether the state is monist or dualist. So I don't know if you've heard these terms before, but essentially states fall into two sort of camps when it comes to international law. If states are monist, they just believe that there is one single unitary one single system of law, with international law at its apex, if you can imagine a hierarchical structure, but that there's no major division between international law and domestic law. Those states are relatively rare. More common is dualist legal systems where states perceive that international law and domestic law are two completely different things. Okay? And that in order for international law to be recognised at the domestic level, meaning that in order for people to be able to rely on rights contained in an international treaty, that a little bit like a foreign currency, you have to take that treaty and incorporate or convert it into a form that domestic law recognises. Okay, and this is the process of incorporation. Now, Ireland has a great history, I don't think it's an exaggeration to say, of signing and ratifying international treaties, but not incorporating them into domestic law. And indeed, it's wonderful that Ireland finally ratified the CRPD this year, but of course, we have not yet done that act of conversion. We haven't incorporated it into domestic law. So we have the Assisted Decision-Making Capacity Act from 2015, but key sections of it have yet to be commenced. We have a Disability Miscellaneous Provisions Bill 2016, but it's only at the second stage in the Dáil, that's one of the Houses of Parliament. And we have the heads of a bill on the deprivation of liberty safeguards, but it's only at public consultation stage, and the public consultation stage closed in March 2018. So we simply haven't got the domestic legislation in place to make the CRPD a meaningful reality at the domestic level. And I'll come back to that point later on. Okay, a few more words now on international law. So international law is the law that governs relations between states. So this is surprising to some people who might not know that much about international law. Very often they're surprised and frustrated at how little the individual can do at international law. But of course, international law is primarily directed towards states. It governs the relations between states, and the states are the primary subjects of international law. International human rights law is a branch of international law, but it has some unique characteristics. It doesn't sit very easily within our typical international law framework. So in international human rights law, states agree with each other about how to treat individuals within their territory. So think about that now for a minute. States are making agreements with each other, with other states, about how each of them is going to treat individuals within their jurisdiction. The individuals are the rights holders and victims, not states. And this has a major knock-on consequence when it comes to the rules of state responsibility. So state responsibility is the area of international law that kicks in when a state violates international law. Okay? So let's imagine that a state signs a fisheries treaty, okay, an international fisheries treaty. And even though it's entering into what we call an obligation erga omnes. It's entering into obligations with all other states parties to that treaty. When it comes to state responsibility, it has a bilateral effect. So you have a victim state. Let's imagine a state who's had its territorial waters invaded by another state, by fisheries vessels of another state. It is a victim state. It engages the responsibility of the violator state, okay? So notwithstanding the erga omnes nature of the obligation, when it comes to state responsibility, what we have is we have a victim state and we have a violator state. And the victim state engages the state responsibility of the violator state and insists on measures of reparation, which might be compensation or whatever. And it can resort to measures of self-help, we call these countermeasures, in order to induce the violator state to come back into line with international law. However, when it comes to international human rights law, the victim is not another state. The victim is an individual within a state, okay? And the individual, as I've mentioned, has no real standing at public international law because the individual is not a subject of public international law. So we often refer to individuals as kind of puny, as seen through the perspective of public international law. So it's very difficult for an individual to engage the responsibility of the state at public international law. Other states, of course, could take up the cause of the individual, since international human rights law is obligations made between states. But we don't see states wanting to contaminate their relations with other states for the sake of individuals in other states. They're not that interested in doing that. So what happens? What happens is that states delegate the monitoring and accountability tasks to a centralised body, and perceived neutral centralised body. For example, the European Court of Human Rights, or the Committee on the Rights of Persons with Disabilities. This body may or may not have legally binding powers depending on the terms of the treaty. So, under the European Convention on Human Rights, the European Court of Human Rights is a court of law with the power to set out legally binding judgments. Unfortunately, when it comes to the UN treaty system, the CRPD being a case in point, the relevant committee, the monitoring body, does not have legal powers to force a state into compliance. That's not the way it works, okay? So that's one effect of international human rights law. And the other is that dualism, okay, I talked earlier on about monism, the idea that international law and domestic law are pretty much the same. Dualism is this idea that they're fundamentally different. So dualism and failure to incorporate, like we have seen in Ireland in respect to the CRPD, have much greater effect than usual. Normally, because states are victims of violations of international law, states engage the responsibility of the other state, and they have various ways of doing that, but they don't do it before a domestic court. But individuals, because they're so puny at public international law, have to rely on the courts. But of course, if they can't, if none of their rights are cognizable by the domestic legal system, they can't do that. Okay? So that is by way of trying to contextualise the CRPD within international human rights law and international human rights law within its broader public international law framework. Now, the CRPD is, of course, only one of 9 core international human rights treaties. When I say international human rights treaties, I mean the UN system. So many of these you will know already. The first 3 treaties were all from 1966, the ICCPR, the ICESCR, and the Convention on the Elimination of Racial Discrimination. Then we had 1 treaty from the 1970s, the Convention on the Elimination of Discrimination Against Women, 2 treaties from the 1980s, the Convention Against Torture and the Convention on the Rights of the Child, 1 treaty from the 1990s, the Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, and then 2 treaties from the noughties, of which the CRPD was the first, the CRPD, and also the Convention on the Protection of All Persons from Enforced Disappearance. Now, we have spoken a lot this morning about intersectionality and multiple forms of discrimination. So on a good news front, the good news is that many of these treaties actually do have similar provisions. So all of these treaties would have provisions, for example, prohibiting discrimination. And as Rosemary spoke about earlier on, prior to the CRPD, discrimination against persons with disabilities was captured under other status. There was no discrete holding place for discrimination against persons with disabilities. So there are some aspects of these treaties that cut across each other. There are some common rights and duties within these treaties. But they are not really a coherent system. They were not designed to be coherent. They were developed in quite an ad hoc way. If you were designing a system of human rights protection, you probably wouldn't design this one. Because there's a lot of incoherences within this system, and sometimes the different monitoring bodies of the different treaties don't speak with one voice when it comes to overlapping rights and duties. So that's by way of the UN Human Rights Treaty System. The CRPD is just one of a series of different human rights treaties. How does this system work? Well, you'll already have been aware, because several people have mentioned it already, that each treaty establishes a treaty monitoring body. And the role of that treaty monitoring body, it's quasi-judicial. It's a little bit like a court, but with a much more emphasis on a dialogic process. So it's a consultative dialogic process where states are encouraged to come into compliance by engaging with states and trying to fill out their understanding of the relevant rights. So every treaty has its own treaty monitoring body, and every state that signs and ratifies a treaty or accedes to a treaty has to fulfill a periodic reporting requirement where it has to report on its progress under that treaty, or its lack of progress, as the case may be. Normally, an initial report has to be submitted after 1 or 2 years, and thereafter, normally a report has to be submitted every 4 years. Now, it's a little odd because states are reporting on themselves, so it's a little bit, like the, fox guarding the hen house. So the state is reporting on how wonderful it is. Having said that, of course, NGOs and civil society institutions, national human rights institutions, can submit shadow reports to the monitoring body, and then there's a dialogue between the monitoring body and the state, which culminates in concluding observations by the committee, which suggest to the state areas where it might progress, areas where it might improve its record, and ways in which this might be done. So it's this dialogic process. It's soft in a sense where states are encouraged to come into better compliance with the relevant treaty. The treaty monitoring bodies also issue, on the basis of those kind of concluding observations and those dialogues with diverse states, they issue concluding observations, which is their views on how particular provisions of a treaty should be interpreted. And indeed, the CRPD, the Committee on the Rights of Persons with Disabilities, has issued 7 different concluding observations on different articles of the Convention to date. Those general comments are of great value to advocates, to researchers in understanding the nature of the legal obligation under the Convention. Some treaties provide for an inquiry procedure. Inquiry procedures are usually available where there's evidence of gross or systematic violations of the treaty. Indeed, in the optional protocol to the CRPD, there is provision for an inquiry procedure, but there's also an opt-out available. So states can sign up to the optional protocol and still opt out from the inquiry procedure. Some treaties have preventive mechanisms. CRPD, for example, provides for monitoring at the national level in Article 33 and provides for the establishment of an independent monitoring mechanism. And of course, monitoring is not just about monitoring violations post hoc, but of course about preventing violations before they actually occur. And then there is often an individual or collective complaints procedure, and this is really important because this is where the committee, the relevant committee, gets to develop its jurisprudence. Okay, so I referred earlier on to the committees as quasi-judicial. So this is the part where the committee gets to act like a quasi-court. It can hear complaints from individuals or groups of individuals. It can adjudicate on those complaints, and it can give its views to the state on how that complaint should be remedied. Whether or not there's an individual or collective complaints procedure is usually laid down in an optional protocol or an optional declaration, and here the CRPD is no different. The individual and collective complaints procedure is laid down in an optional protocol. Unfortunately, Ireland has not ratified the optional protocol. One thing to note about all of this, so on the one hand, there's lots of interesting normative output by treaty monitoring bodies. We have these concluding observations, we have general comments, we have the results of inquiries, we have national institutions developing their own norms. We have complaints procedures where the committee has adjudicated on complaints. All of these are a rich source of norms. However, none of this jurisprudence is legally binding per se. Okay, so that could either be regarded as a major weakness of the treaty monitoring system. I don't regard it as such, because you will remember at the beginning of the presentation I referred to customary international law as being a primary source of public international law. And customary international law is when states follow a particular practice and eventually they come to believe that that practice has acquired the status of law. And of course, if treaty monitoring bodies are continuously saying the treaty should be interpreted in this way, and that interpretation gains traction with states and more states start to follow suit, then that becomes customary international law. But it is a long process. Okay, now, the UN treaty system is not the only, it doesn't operate in isolation. There's a much larger context to the UN treaty system. It's in a sense just one small jigsaw piece in a much larger human rights jigsaw. Also within the UN system, we have the UN Human Rights Council. You may have heard of the Human Rights Council, also sits in New York and Geneva. It is the largest intergovernmental body charged with monitoring human rights. It is a sub-organ of the UN General Assembly, and it's made up of states. So I suppose here's a major difference between the treaty monitoring bodies like the Committee on the Rights of Persons with Disability that's made up of independent experts. The Human Rights Council is an intergovernmental body that's made up of diplomats essentially representing states. But the Human Rights Council functions quite similarly, so it has a universal periodic review where it invites states to comment on their own human rights record, and then there's a dialogue. It also responds to complaints made by individuals and groups of individuals against states. And importantly, it has a large number of what we call thematic mechanisms, sometimes known as special rapporteurs or working groups or experts on particular areas. And these are independent experts. And the role of these special rapporteurs or thematic mechanisms is to, again, develop normative criteria and develop our understanding of different rights. So I'll just mention a number of the thematic mandates that may be of interest in the disability law context. Of course, there's a special rapporteur on the rights of persons with disabilities. There's a special rapporteur on the right to health, and I think, if I'm not mistaken, we heard from him at this summer school last year. And there's a working group on arbitrary detention. So there's many, I can't list them all out here, but many have a mandate that is either directly relevant to disability rights or is overlapping. So we have the UN Human Rights Council and its thematic mandates working away tangentially with the treaty monitoring bodies. We also have the UN organs making hard and soft law. So what are the UN organs of relevance? Well, we have the General Assembly. So the General Assembly, and of course the CRPD was adopted by the General Assembly. The General Assembly is the Parliament, in a sense, of the United Nations. And the General Assembly can pass a resolution by majority voting on any matter that it sees fit. So it's always up to the General Assembly to adopt resolutions on practically anything. So they're busy doing their work. We also have the United Nations Security Council, which is the primary organ of the United Nations that's entrusted with maintaining international peace and security. And when they adopt resolutions under Chapter 7, they are legally binding. We also have the International Court of Justice. So this is the court where states can take each other to court if they perceive that the other state is violating international law. Also, the different organs of the United Nations can request the court to give advisory opinions on matters that fall within their mandate. So the organs of the United Nations are busy working on human rights issues as well and produce many important resolutions which may constitute soft law, which may ultimately contribute to customary international law, or indeed hard law, some of which may pertain to human rights, some of which may even pertain to disability rights. And then we have all the UN agencies, which now if you read the mandate of any of the UN agencies, you'll see that mainstreaming human rights is part of the function of all UN agencies now. So when I talk about UN agencies, I'm referring to the likes of the United Nations Development Programme, UNDP, UNICEF, that's the Children's Fund, the World Health Organization, UNHCR, the United Nations High Commissioner for Refugees, and so on. There's so many different UN agencies. In the past, UN agencies used to think that their role was just to do what it said on the tin. So the UNDP used to just do development, but now, of course, UNDP does development through a human rights lens. So they're all trying to mainstream human rights into the core functions of what they do. So that's just within the UN system. So you can see that in addition to the treaty monitoring bodies, we have an array of other bodies that are busy doing human rights work to greater or lesser extents. Then we add the regional systems into the mix, like the European Convention on Human Rights. Here we might also mention the EU, which of course, much of equality and anti-discrimination now is not coming actually from the European Court of Human Rights, it's coming from the EU, and of course disability rights are mentioned in the Charter of Fundamental Rights of the EU. And then we might add other overlapping branches of international laws. If this picture, as if this jigsaw wasn't complicated enough, we'll add into the mix other overlapping branches of international law. My own area is international refugee law. And one thing that we're talking about in international refugee law at the moment is to what extent can persons with disabilities be recognised as refugees for that reason under the Refugee Convention. Okay, so the Refugee Convention is primarily about people who have a well-founded fear of persecution for one of 5 reasons associated with their identity: race, religion, nationality, social group, or political opinion. And there's a big debate now in refugee law about whether persons who have faced persecution because of their disability, do they fall within one of these 5 grounds: race, religion, nationality, membership of a particular social group? Is having a disability, does that make a particular social group? What if, like someone this morning alluded to, what if you have a disability, but it's not widely perceived that you do, but you are still being persecuted for that reason? Do you fall within, the definition of a refugee? So this is animating a lot of refugee lawyers at the moment. Another area of refugee law is, when a refugee arrives, they have to go through an interview procedure. And you are very unlikely to get recognised as a refugee if you do not present a coherent, systematic, linear account of your reasons for having to leave your country of origin. Now, that's a very big ask for certain cohorts of people. One might think of people with certain disabilities who would find it very difficult to articulate a claim like that. Another group would be children, for example. So what are the hidden barriers within the refugee status determination procedure that prevent persons with disabilities from getting recognised? And then a last area of refugee law that we're busy looking at the moment is, when refugees or asylum seekers arrive into a state, they have to be received, they have to be hosted in some sort of accommodation. Well, what kind of accommodations, reasonable accommodations, are made or not for persons who have disabilities? So I mention these just to say that it seems at first glance that international refugee law doesn't have much to do with disability rights, but of course it absolutely does. So we have these other branches of international law which seem at first to be discrete, but actually are quite overlapping. And then finally, let's add into the mix domestic policymakers and domestic courts, which are at the forefront of the coalface of what's happening at the domestic level, many of whom are not disability rights experts, it has to be said. Okay? So now what do we have? We have the UN treaty monitoring bodies, we have a broader UN system, we have regional human rights systems, we have other overlapping branches of public international law. What do you get from all this? You get huge potential for norms to clash. This is my second last point, you'll be happy to hear. And we see this clash this clash is highly visible in certain, particularly when it comes to certain key rights. If you take the right to liberty, for example, the CRPD in Article 14 says quite clearly that the right to liberty and the prohibition on arbitrary deprivation of liberty prohibits the incarceration of someone purely on the grounds of having a disability. Whereas Article 5.1e of the European Convention on Human Rights provides for the lawful detention of persons of unsound mind. I know it's very archaic language, but that's the language of the European Convention on Human Rights. So we have clashing norms here, which raises the question, how should treaties be interpreted and reconciled? What do we do, for example, when we have a state party, like Ireland, to the CRPD, that's appearing before the European Court of Human Rights because they have incarcerated or detained somebody because they are of unsound mind. Which norm applies? Well, it's not, the answer is not straightforward. In general international law, where successive treaties govern the same subject matter, there's two general rules of thumb. Later trumps earlier. Okay, that sounds good. And specialised trumps general. So Rosemary referred earlier on to lex generalis and lex specialis. So this is what she was referring to. However, human rights treaties are more self-contained. So I can guarantee you, if you as a litigant go before the European Court of Human Rights and try to argue the CRPD, the court will say to you, we're not applying the CRPD, we're applying the European Convention on Human Rights. Having said all that, this is mitigated somewhat by what we call the harmonious or schematic approach to treaty interpretation. Okay, what do I mean by that? Well, there's a sort of a rule of thumb about how any international treaty should be interpreted, and this is laid down in Article 31 of the Vienna Convention on the Law of Treaties. And Article 31 says, a treaty shall be interpreted in good faith, in accordance with the ordinary meaning given to the terms of the treaty in its context and in the light of its object and purpose. Okay, that's what we call the schematic. So you don't take an article of the CRPD or the ECHR and just give it a literal interpretation. You have to interpret a particular provision in the light of the overall object and purpose of the treaty. The Vienna Convention goes on to say, there shall be taken into consideration, together with context, any relevant rules of international law applicable in the relations between the parties. Okay? So let's now imagine our litigant is before the European Court of Human Rights, trying to argue that Article 5 ECHR should be interpreted through the lens of the CRPD. Well, an argument that they might make is, well, practically all member states of the Council of Europe, which is the governing body of the ECHR, practically all members of the Council of Europe are signatory states to the CRPD, and therefore the CRPD Article 14, governing deprivation of liberty, is a relevant rule of international law from the point of view of interpreting the ECHR. And of course, the European Court of Human Rights itself often says things like, we want the rights in the Convention to be practical and effective, not theoretical and illusory. And often the court will look for a European consensus. And the fact that the vast majority of members of the Council of Europe have signed and ratified the CRPD, is evidence of that European consensus now. However, we should always be mindful of the fact we are talking about two separate treaties. Yeah. So I have 1 minute left to talk about reservations and declarations, the thing that I was asked to speak about at the very beginning. So I'm assuming that everyone knows what they are, but it's actually not that obvious, because reservations, when we look at the Vienna Convention on the Law of Treaties, reservations are defined, but declarations aren't. Essentially what a reservation is when a state signs a treaty, it might enter a reservation in respect of a particular article of the treaty, saying that that article does not apply to the state. Okay? What is a declaration? It's just a variation on a reservation, where a state might enter a declaration and say, well, we accept this particular article, but this is our understanding of what the article means. Okay? So that's the difference between the two. But the Vienna Convention only talks about reservations. So first of all, why are states permitted to enter these reservations and declarations? Well, it sort of greases, it smooths the waters to facilitate states being bound by the treaty. If there's an absolute no-no for a state contained in a particular article, they might be minded just to say, well, we can't ratify, and walk away from the negotiations. However, if they might be persuaded to ratify if they could simply enter a reservation or a declaration. So it's a way to smooth the waters and to get states to buy into treaty rights. What is the effect of a reservation? It excludes or modifies the legal effect of that particular provision. Okay, so Ireland has entered 3 reservations/declarations, you're probably aware. I won't go through them now because I don't have time. But what Ireland is purporting or attempting to do there is saying this provision either doesn't apply to us, or it doesn't apply to us in the way you might think. It applies to us in the way we think. Okay, and then Ireland goes ahead and gives its interpretation of the particular provision. Are there any limits on states' freedom to enter reservations? Well, a reservation cannot be incompatible with the object and purpose of a treaty. There's one reservation that Ireland has entered into in respect of Article 27, which is equal treatment in employment. And it's all about reasonable accommodation. And basically, Ireland has said that it will not apply to employment in the Defence Forces, in the police, in the prison service, the fire brigade, the Coast Guard, or ambulance service. So it's a wholesale sort of declaration in relation, well, it is a reservation in essence, because it's saying that that particular provision will not apply to this host of public services. Arguably, that is incompatible with the object and purpose of the treaty, but perhaps that's a discussion for another day. And also the other thing to be clear about is that reservations should be narrowly construed, because they are an exception to general rules of treaty interpretations. Importantly, I'll end on this point. How do we get states to withdraw their reservations and declarations? Well, this is part of the dialogic process that I referred to earlier on. This is where civil society organisations come into the fore. This is where NGOs and national human rights institutions, when they submit their shadow reports to the treaty monitoring bodies, really go hard on states and say, this reservation or this declaration is incompatible with the object and purpose of the treaty, and we insist that you withdraw it. And then hopefully the treaty monitoring body will take up that cause and put a lot of pressure on the state to withdraw. But in the end, you have to remember that it's all about state consent, and that in the end the state will decide whether or not it will withdraw its reservation or declaration. I'll leave it there. Thank you.